Welcome to Deep Dive. Today, we're really digging into something that's causing, well, a lot of anxiety for thousands of families. We're talking about recent, very impactful changes to U.S. immigration policy.
That's right.
Specifically, we're going deep on the Child Status Protection Act, or CSPA, and how these new rules for calculating a child's age could drastically change futures for young people trying to get lawful permanent resident status here in the U.S.
It's a really critical issue right now.
Yeah, for so many people, trying to understand immigration regulations can feel less like a clear system and more like, well, a maze.
Especially when things change like this.
Exactly. So our mission today is to try and cut through that complexity, show you what these developments really mean for families, and maybe explore some potential paths forward.
We've looked at the key details to help grasp the nuances.
Okay, let's start right at the beginning then. What exactly is the Child Status Protection Act?
Yeah.
What problem was it originally trying to solve?
Sure. So CSPA, it's a really key piece of legislation. It was designed essentially as a safety net. Normally, U.S. immigration law defines a child as someone unmarried and under 21.
Right.
But the visa processes, especially for employment-based paths, can take years, sometimes even decades, because of the backlogs.
Huge backlog.
Yeah. So without CSPA, a child could just turn 21 while they're waiting.
And just age out.
Exactly, age out.
Yeah.
And they'd lose their chance to immigrate with their family as a derivative beneficiary, meaning, they were included on their parents' application.
So CSPA is kind of like a time stopper then for their age in this incredibly long process.
In a way, yes. It provides a method to calculate what we call a CSPA age.
Okay.
For employment-based categories, specifically, this CSPA age is worked out by taking the child's actual age on the day a visa becomes available.
And that becomes available part sounds key.
It is absolutely key. We'll definitely circle back to that. But you take their age then, and you subtract the total time the underlying immigrant petition, like the I-140, the employer's petition was pending, waiting for approval.
Okay.
If that calculated CSPA age is still under 21, then for immigration purposes, they can still be considered a child. It's really about making sure the long wait time itself doesn't unfairly disqualify them.
Got it. That makes sense. But you mentioned that phrase becomes available is key, and it sounds like this whole situation has a history, policies shifting back and forth.
It really has.
Can you walk us through how the calculation of visa availability has changed? Because that seems to be the crux of the recent changes.
Absolutely. This is the core question. When exactly does a visa become available for CSPA purposes? And the definition has, evolved. For many years, actually, between when CSPA started in 2001 and October 2015, and then again under guidance from May 2018, U.S. Citizenship and Immigration Services, USCIS, they generally considered a visa available based only on the final action dates chart.
That's the chart in the State Department's visa bulletin.
Exactly. The visa bulletin, that chart basically tells you when a visa is actually authorized to be issued. It's the final green light, you could say.
Okay, final action dates. Got it.
Then things changed. In February 2023, USCIS updated its guidance. They wanted to address some inconsistencies, so they changed their interpretation. They started considering a visa available for the CSPA age calculation at the same time it was considered immediately available for someone to actually file their adjustment of status application, the I-485.
So using the other chart in the visa bulletin sometimes, the dates for filing chart.
Precisely. That chart often has much earlier dates, sometimes years earlier. So if USCIS said, okay, you can use the dates for filing chart to submit your green card application, then under that February 2023 policy, you could also use that earlier date for the CSPA age calculation.
Which sounds much more helpful for families.
It generally was, yes. It was seen as more lenient, offered more protection against aging out. It widened that window of opportunity.
Okay, so that was the February 2023 policy, but now?
Right. Now we get to the really crucial part, and honestly, where all the recent anxiety is coming from. USCIS issued new policy guidance, and it takes effect August 15, 2025.
Which is just days away from when we're recording this.
Exactly. This new guidance clarifies that a visa becomes available for CSPA age calculation based only on the final action dates chart again.
Wow. So it's reverting back.
It's reversing the February 2023 policy, but specifically for new filings submitted on or after August 15, 2025.
Okay, hold on. So if you're listening to this deep dive right now, on August 12, 2025, you potentially have just 3 days left today, tomorrow, and the next day to file an adjustment application if you're eligible to maybe get under that older, more lenient February 2023 rule.
That's the implication, yes. Applications filed before August 15, 2025 are supposed to be processed under the February 2023 policy.
That's what they call grandfathering.
Correct. That grandfathering provision is incredibly important for anyone with a pending application or anyone who might just squeak in before the deadline. But after that date,
It's back to the stricter final action dates rule. That's a huge shift.
it is a very significant shift.
So we understand the what and the how now, but the big question is why? Why is USCIS making this change now, going back to what seems like a less favorable rule for many?
Well, the official reason given is about creating consistency.
Consistency, how so?
There was this difference, right?
Yeah.
Between how CSPA age was calculated for people applying for adjustment of status inside the U.S. with USCIS, and those applying for immigrant visas through consulates abroad, which is handled by the Department of State.
Oh, okay.
The Department of State, for those consulate cases, has always used the final action dates chart for CSPA calculations consistently.
I see.
So this new policy brings USCIS's method back into alignment with what the Department of State does, making it uniform across the board.
So it's about uniformity, aligning the agencies, even if that uniformity means less flexibility and potentially more heartache for families applying within the U.S.
That seemed to be the trade-off, yes.
Right.
Streamlining the process internally, but with potentially very significant external impacts.
Let's talk about those impacts, because that desire for uniformity, as you said, it creates new challenges. What does this mean on a really personal level, especially for those young people often called legal dreamers?
Yeah, the implications are profound, especially for families already facing those incredibly long waits for green cards, because the final action dates are almost always later, sometimes much later, than the dates for filing.
Right.
Fewer applicants are likely to qualify for CSPA protection now. It just mathematically increases the risk of aging out, turning 21 and losing eligibility to stay with their parents.
And the legal dreamers, how does this hit them specifically?
So, legal dreamers. That term usually refers to children who came here legally, often as dependents of parents on temporary work visas like H-1Bs or L-1s. They grow up here, go to school here, build their lives here. But their legal status is tied to their parents.
Until they turn 21.
Exactly. If their parents' green card isn't approved before they turn 21, and if CSPA doesn't protect them, they can lose their legal status. And the numbers are staggering. Some estimates suggest hundreds of thousands of children are in this employment-based green card pipeline,
Wow.
with potentially over 100,000 at risk of aging out in the coming years. It's really tough to think about growing up somewhere, it being your home, and then facing deportation because of a date on a chart.
Absolutely devastating. And you mentioned earlier, this doesn't affect everyone equally, does it?
No, definitely not. The data clearly shows that certain nationalities face much, much longer backlogs, particularly people from India and China in the employment-based categories.
Right, I saw a figure that Indian nationals make up something like 62% of the employment-based backlog.
That's consistent with what we've seen, yes. So this rule change disproportionately impacts children from those countries, kids who might have spent 10, 15, even 20 years living legally in the U.S.
The uncertainty must be immense.
It causes huge emotional and financial strain. It disrupts everything: education plans, healthcare, career thoughts. Immigration lawyers are reporting just a flood of calls from worried parents trying to figure out what this means.
And it's not just the families feeling this, right? What about the employers who sponsor these workers?
That's a really important point. For businesses, this adds complexity. It can create real challenges for employee retention and recruitment. They might need to push for faster processing, maybe use premium processing for the I-140s if possible. They definitely need good immigration counsel to guide employees.
And it could even affect the U.S.'s ability to attract talent globally.
Potentially, yes. If it becomes much harder for skilled workers to keep their families together here, that could make other countries look more attractive. It impacts competitiveness.
Okay, so we have the age calculation, the date change. But there's another piece too, isn't there? Something called the sought to acquire requirement. How does that fit in?
Yes, that's another critical layer. It's not enough just to have a CSPA age under 21. To actually get the benefit of CSPA, the non-citizen must also seek to acquire lawful permanent resident status within 1 year of their visa becoming available.
And seeking to acquire usually means filing the green card application, the I-485.
Generally, yes. Filing the I-485 adjustment of status application is the most common way to meet that requirement. It shows you're actively pursuing residency.
What if something prevents someone from filing within that 1 year? Life happens, right?
It does. And USCIS policy does account for that to some extent. There's a provision for extraordinary circumstances.
Okay. What qualifies as extraordinary?
Well, it's discretionary, meaning USCIS decides case by case. But it could be things genuinely beyond the applicant's control, like a serious illness, maybe a natural disaster that disrupted things, or sometimes even a significant error made by an attorney or USCIS itself. If such circumstances prevented filing within the one-year window, USCIS may excuse the delay.
Is that provision used often?
It's case-specific, but interestingly, USCIS actually clarified this policy relatively recently, back in September 2024. They aim to provide more guidance on situations where factors outside the applicant's control prevented them from meeting that one-year deadline. So there is some flexibility built in, even if it's discretionary.
That's good to know. A little bit of leeway in a very strict system.
A little bit, yes.
This is all still quite complex, though. The dates, the calculations, the requirements. It feels like the timing is everything. Can we maybe walk through a simplified example just to see how this plays out for a hypothetical family?
Sure, let's try that. It really helps illustrate the difference. Imagine a family. The parent has an I-140 petition filed by their employer. Let's say that petition took 4 months to get approved.
Okay, 4 months pending time.
Right. And at the exact moment the I-140 is approved, their child is 21 years and 1 month old, just over the line.
Okay.
Now let's apply the old February 2023 policy. Under that policy, we look at the dates for filing chart. Let's say, in our example, that chart becomes current for their category in the same month the I-140 is approved.
So they can potentially file right away.
Exactly. So the CSPA calculation would be 21 years, 1 month, the child's actual age, minus those 4 months the petition was pending.
Which brings them down to 20 years and 9 months.
Right, under 21. So under the old policy, this child qualifies for CSPA protection. They're considered a child.
Okay, clear enough. Now, the same family, main situation, but under the new policy effective, August 15th, 2025.
Right. Now, they cannot use the dates of filing chart for the CSPA calculation. They must wait for the final action dates chart to become current.
And that's usually later.
Often, yes. Let's say, in our example, the final action date doesn't become current for another 5 months after the I-140 approval.
Oh, okay.
So by the time their visa technically becomes available under the new rule, the child's actual age is now 21 years and 6 months. 1 month plus the extra 5 months?
Right.
Now we do the calculation. 21 years, 6 months, minus the same 4 months the petition was pending.
That leaves 21 years and 2 months.
Exactly, over 21. So under the new policy, this child, unfortunately, ages out. They are no longer eligible to immigrate as a derivative with their parent.
Wow. That example makes it incredibly clear. The exact same family, the exact same petition time, but the timing of when the government says a visa is available completely changes the outcome.
Precisely. It shows the impact isn't just how you calculate, but when you get to do the calculation. And that gap between the two chart dates can make all the difference.
So, given this new policy, the tighter rules, the potential for more kids aging out, what can families and maybe their employers actually do? What are the options or recommendations now?
It definitely calls for very careful, very proactive planning. For families, the most urgent advice, especially as we record this just before the deadline, was if a child is nearing 21 and you are eligible to file the I-485 based on the dates for filing chart before August 15th, 2025.
Do it immediately.
Yes, file immediately to try and get grandfathered under the old, more lenient policy. That window is basically closed now, but it highlights the kind of urgency needed.
Okay, beyond that very immediate deadline action, what's the advice moving forward?
Number one, absolutely consult with an experienced immigration attorney right away. They need to analyze your specific dates, calculate the CSPA age under the new rules, and advise on any immediate steps. This is not something to guess on.
Definitely need professional advice.
For sure. Then, for children who might age out under the new rules, you have to explore alternatives. It's tough, but necessary. One option might be changing their status to an F1 student visa to continue their education. Although, as we noted, there's guidance telling officers to look at their present intent to leave after studies, which can be tricky for someone who grew up here.
Right. What else?
If they qualify based on education and a job offer, maybe an H-1B employment visa could be a path down the line. Or, for families with significant financial resources, the EB-5 investment visa program offers a completely separate route to a green card.
So exploring all possible avenues.
Every single one. And for employers.
What should they be doing?
Employers really need to understand this new policy too. Consult their own immigration counsel. And then, crucially, communicate proactively with their affected employees. Let them know about the change, the potential impact on their families, help them connect with legal resources.
And maybe adjust their own strategies.
Yes, they should think about how this might affect retention, especially for key employees facing potential family separation. Maybe look at timing strategies for green card filings. Consider premium processing more often. It really becomes part of their overall talent management strategy now.
This has been a really insightful deep dive. It truly highlights how complex and, frankly, how personal immigration law is.
Absolutely.
For so many families, these aren't just, technical updates on a website. They have absolutely profound implications for their future, their stability, their entire lives here in the U.S.
And it's fascinating, isn't it? How a seemingly small technical adjustment, just changing which date you use from the visa bulletin for an age calculation, can create such huge real-world challenges. It really underscores why people need to be so diligent and stay informed about these constantly shifting immigration landscapes.
Indeed. So what does this all mean for you, our listeners? It means staying informed is critical. It means seeking professional guidance and doing it quickly if you think you might be affected. And it means exploring every available avenue to navigate these evolving regulations. As we've discussed, the main takeaway is this. The updated USCIS policy, effective August 15, 2025, reverts to using the final action dates chart for Child Status Protection Act age calculation.
Right, and this potentially puts more children at risk of aging out.
Particularly those from countries like India and China with those very long visa backlogs.
So families and employers really need to be proactive in understanding these changes.
And exploring alternative immigration pathways or legal strategies to protect eligibility wherever possible. It's a lot to navigate. All the best in navigating these important matters. And we will meet again with another important subject in the next meeting.